Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, Wills and Succession Overview. Let's begin. Wills and succession on the California Bar exam is a California probate code subject. The core tasks are determining whether a testamentary document is valid, what property passes under it, who takes if it fails, and whether a contest or construction doctrine changes the result. Always distinguish probate transfers from non-probate transfers such as trusts, joint tenancy, beneficiary designations, pay-on-death accounts, and life insurance. A will is ambulatory. It speaks at death and can be revoked during life. A person who makes a will is a testator. A person receiving personal property is a legatee. Real property recipients are often devisees, though modern usage often says beneficiary. California recognizes formal attested wills and holographic wills. It also has statutory harmless error concepts that may validate defective writings if clear and convincing evidence shows testamentary intent. Start every essay with capacity and formalities if validity is an issue. Then analyze revocation, revival, codicils, incorporation by reference, acts of independent significance, omitted spouse or child, intestacy, and construction doctrines. Capacity. A testator generally must be at least 18 and of sound mind. The testator must understand the nature of the testamentary act, understand and recollect the nature and situation of property, and remember and understand relations to living descendants, spouse, parents, and those whose interests are affected. Mental disorder may invalidate a will if it causes delusions or hallucinations resulting in a disposition the testator would not otherwise have made. Formal attested will. Under California Probate Code Section 6110, a will generally must be in writing, signed by the testator or by another in the testator's presence and at the testator's direction, and witnessed by at least two persons present at the same time who understand the instrument is the testator's will and signed during the testator's lifetime. Holographic will. Under Probate Code Section 6111, a holographic will is valid if the signature and material provisions are in the testator's handwriting. It does not require witnesses. Testamentary intent can be shown by the document itself or, in some circumstances, extrinsic evidence. Intestacy. If no valid will disposes of property, California intestacy statutes distribute probate property to surviving spouse or domestic partner and descendants, parents, siblings, and more remote relatives according to statutory priority. Will execution. Writing.
Testatoresse signature or autorise de signature.
Two witnesses present at the same time. Witnesses understand the document is a will. Witnesses signed during testator's lifetime. If a defect exists, consider California's harmless error rule requiring clear and convincing evidence the testator intended the document to be a will. Revocation. By subsequent will or codicil expressly revoking or inconsistently disposing of property. By physical act such as burning, tearing, canceling, obliterating, or destroying, done with intent to revoke by testator or by someone in testator's presence and at direction. Revocation can be partial or total if intent and act support it. Lost will presumptions may arise if the will was last in testator's possession and cannot be found after death. Will components. Codicil modifies, republishes, or supplements a will and must be executed with testamentary formalities. Incorporation by reference requires an existing writing, sufficiently identified in the will, with intent to incorporate. Acts of independent significance allow a will to dispose by reference to acts or facts with lifetime significance apart from testamentary effect. Pour-over gifts to a trust are valid if statutory requirements are met. Probate versus non-probate. A will controls probate assets only. It does not usually override joint tenancy survivorship, trust terms, life insurance beneficiary designations, retirement accounts, or transfer-on-death designations unless those instruments are changed according to their rules. Attested will versus holographic will. An attested will depends on witnesses and signature formalities. A holographic will depends on handwriting of signature and material provisions. A typed document with handwritten changes may be partly valid as holographic only if material provisions are handwritten. Codicil versus new will. A codicil republishes a will as of the codicil date unless contrary intent appears. This can cure some issues, change dates for interested witness analysis, or affect incorporation by reference. Intestacy versus omitted heir statutes. Intestacy applies to property not disposed of by will. Omitted spouse and omitted child statutes can give a statutory share even when a will exists, unless exceptions apply. Do not forget interested witnesses. A gift to a witness may be presumed procured by duress, menace, fraud, or undue influence unless rebutted, but the will itself can remain valid. Do not assume a handwritten note is a holographic will. It must show testamentary intent and contain material provisions in handwriting. Do not apply will rules to trust assets without analyzing the trust. Do not forget anti-lapse. California may save gifts to certain kindred who predecease the testator if they leave issue, unless contrary intent appears. Do not confuse ademption by extinction with abatement. Ademption concerns specific gifts no longer in the estate. Abatement reduces gifts when the estate lacks enough assets. A typical essay includes a formal will, a handwritten note, a later crossing out, a predeceased beneficiary, a new spouse or child, and property that changed form. Work in order. First, identify valid testamentary instruments. Second, determine revocation or republication. Third, construe gifts. Fourth, apply doctrines such as anti-lapse, ademption, omitted spouse or child, and intestacy. Fifth, address contests. If there is a handwritten document, quote the rule for holographic wills and apply it to signature, material provisions, and intent. If there are witness problems, discuss formal execution and harmless error. If there are suspicious beneficiaries, discuss capacity, undue influence, fraud, duress, and interested witness consequences. End with distribution. Bar examiners want to know who takes what. A great answer does not stop at saying a clause is invalid. It follows the property to another clause, residue, intestacy, or non-probate transfer. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.